Today, Supreme Court has delivered the verdict on the question as to who controls the civil servants posted in the government of Delhi. Is it the center or is it the government of Delhi which has administrative control over the civil servants in Delhi government? Before we look at the verdict of the constitutional bench and analyze point by point all the observations, let us have a quick look at the various arguments put forth by the government of Delhi and the union in Supreme Court. Let's have a look at the arguments put forth by the government of Delhi. First argument is that the control over civil servants in Delhi government should lie with the government of Delhi because it is essential to ensure the chain of accountability. This chain of accountability will later be referred by Supreme Court as a triple chain of accountability. In the sense, the civil servants are responsible for the implementation of various policies made by the political executive. And therefore, civil servants should be accountable to the political executive. The political executive, in turn, is accountable to the elected representatives who are members of Delhi Legislative Assembly. And the elected representatives are then in turn answerable, accountable to the people of Delhi. And this makes it a triple chain of accountability. So if the political executive is accountable to the legislature, then the political executive of Delhi should also have administrative control over the civil servants. This was the first argument put forth by Delhi government. Second, no federalism if local or state governments cannot control staff or the civil servants. Federalism means a vertical division of powers between the union and states, and then further states and the local governments. Federalism does not mean that the union can still have the control over the subjects which are otherwise under the control of the state or the local governments. So if the control of the civil servants, the IAS and IPS officers posted in Delhi government is still with the union, then that will seriously erode or take away the powers of Delhi government. And that will be violative of the spirit of federalism. And I'm sure this is known that federalism is a part of basic structure of constitution. The third argument of Delhi government was that the administrative control over civil servants is essential for a functioning of government. Because if government has to fulfill the promises made to the people, it cannot be done without having an administrative control over various departments and the civil servants posted and working in these departments. And therefore, this administrative control becomes essential. And fourth argument is Article 239AA has granted the Legislative Assembly of Delhi significant executive powers to make laws on matters within its legislative competence. To understand this point, we have to go back into the background of Article 239AA. This article was added by Parliament by 69th Constitutional Amendment Act 1991, which first of all designated Delhi as National Capital Territory of Delhi. This amendment added Article 239AA with special provisions only for Delhi. According to these special provisions, Delhi will be having a legislative assembly. But how many members in the assembly? That shall be determined by a law of Parliament. In pursuance of this power, Parliament enacted the Government of Delhi, the Government of NCT of Delhi, Delhi Act 1991, which has given Delhi a legislative assembly of 70 members. This assembly shall have the powers to make laws on subjects of state list and concurrent list, except three subjects of state list. and that is police, public order, and land. That means except these three matters, the Delhi Legislative Assembly has legislative competence to make laws even on the matter of services. So services is a matter which comes under state list. Therefore, except these three matters of state list, Delhi Assembly has the powers to make laws, and therefore the concurrent executive power over the services is also with the state government of Delhi. Now let us look at the arguments put forth by the union. First is that Delhi is the national capital and therefore holds strategic importance. So the argument of union is that because Delhi is the national capital, the union must have a control over the territory of Delhi. And therefore, the LG of Delhi must have his say in certain policy matters. Second, LG was the representative of the president and a constitutional functionary and not just an officer. No doubt that the constitutional position of LG cannot be called as similar to or equivalent to the position of governor, who is the head of state. But that also does not mean that the LG is just an officer and has no constitutional powers. It is because the governance of UTs is as per the Part 8 of Constitution from Article 239 onwards. And the Part 8 is clear that the UTs shall be administered by the President through an administrator appointed by the President. And that makes the LG of Delhi an administrator, a constitutional functionary. And therefore, he must have his say or his opinion on various governance matters in the government of Delhi, and that includes the control over the civil servants. Third argument of union: no question of federalism in UTs, as there were mostly no elected government in UTs. Yes, so UTs, I'm sure you people understand, are not considered as part of our federal system. When we refer to India as a federal country, it refers to the union and the states and not to the UTs, because UTs are administered, are controlled, are taken care by the union government. And there is no vertical division of powers between union and UTs the way it is between union and the states. Therefore, the argument of the union is that there is no question of federalism in case of UTs. And therefore, the power lies with the union. But the UT of Pondicherry, the UT of Delhi, and very soon the UT of J&K, these are the UTs for which a provision has been given for their legislative assemblies. And therefore, we can say that in context of these three UTs, there is a kind of hybrid federalism. That means there is a federalism, there is a sharing of powers, but with supremacy of the center. This is the argument put forth by the center. So center is not ready to allow Delhi, Pondicherry, and J&K to have complete independence over the matters of state list and concurrent list the way the rest of the states of India have. Let's now look at the Supreme Court verdict as delivered by the Constitutional Bench. Supreme Court holds that National Capital Territory of Delhi has legislative and executive power over services. So Supreme Court has categorically made it clear that it is the government of Delhi which has both legislative as well as executive power over services in Delhi. However, it would not extend to the services which come under the three subjects: public order, police, and land. So we have already seen that these three matters or these three subjects have been excluded from the control, the legislative control and executive control of the government of Delhi. And therefore, the officers posted in these three departments may not be said to be under the administrative control of Delhi government. So apart from these three subjects, the LG, the Lieutenant Governor, shall be bound by the decision of NCT of Delhi over services apart from these three subjects. Second, observation of the court. The phrase insofar cannot be read to exclude further legislative powers of the National Capital Territory of Delhi. Let's understand this. Now, this phrase insofar is mentioned in Article 239 AA subclause 4. This article says that in Delhi, there shall be a council of ministers with the chief minister at the head to aid and advise the LG of Delhi in his executive functions, except insofar the LG is supposed to exercise some functions in his discretion. The Supreme Court says that these words, except insofar, they cannot be construed, they cannot be interpreted to mean that LG can have powers or can have interference in matters which have not been excluded from the purview of Delhi government. So LG can have his opinion, can have his say in matters of police, public order and land, but not on other matters over which the Delhi Assembly has legislative powers. So let's read again this argument. The court observes that the phrase insofar as cannot be read to exclude further legislative powers. That means legislative powers on three subjects have been already excluded by the Constitution. Now, the words insofar cannot be interpreted to further exclude the powers from the National Capital Territory of Delhi. Third, the Chief Justice of India observed that the Union of India has only executive power only over three entries in list 2. List 2 is in 7th schedule. That is a state list. And which three entries? I'm sure you all know very well. Public order, police and land. National Capital Territory of Delhi is not similar to other union territories. So one of the arguments that we saw a while back of the union was that Delhi is a UT and therefore Delhi comes under the control of the union. The Supreme Court and even the CJI observes that no, the status of Delhi, and we can even extend this logic to the UT of Pondicherry and J&K, is that they are not just UTs, because unlike other UTs, these three UTs have been given a democratically elected representative government. And therefore, you cannot compare these three UTs. In this context, it's Delhi in question. So you cannot compare Delhi with other UTs. Next, Honorable CJI observed that National Capital Territory of Delhi is similar to other states, represents the representative form of government. So like other states have a democratically elected representative government, similarly, Delhi also have a government elected by the people of Delhi. Any further expansion of union's power will be contrary to the constitutional scheme. So Constitution envisages a division of powers between union and the UT of Delhi as per Article 239 AA. So except three matters, the Delhi government has been given legislative and executive powers. If those powers are further eroded by the union, then this will be contrary to the constitutional scheme. Further, the court observed, if services are excluded from legislative and executive domain, the ministers would be excluded from controlling the civil servants who are to implement the policies. So various IAS, IPS and other officers who are posted in various departments of Delhi government, if those officers cannot be controlled, cannot be held accountable by respective ministers, then how is the Delhi government going to fulfill its promises or its responsibilities towards the people of Delhi? If the officers feel that they are insulated, they are shielded from the control of the government, the ministers, it will dilute accountability and affect the governance. So imagine if I'm an officer in any department of government of Delhi, and I know that my minister can't control me, he can't transfer me, he can't change my profile, then can my minister control me? No. So this is what CJI observed. Further, Honorable CJI said that if the officers stop reporting to the ministers or do not abide by their directions, the principle of collective responsibility is affected. I'm sure all of you understand that the principle of collective responsibility is considered as the foundation of parliamentary system. In context of union, this principle is according to Article 75, Clause 3 of our Constitution. So as I give you an example, that if I'm an officer in any department of government of Delhi, and if I know that I cannot be controlled or my administrative control is not with my minister, so what may I do? I may stop reporting to my minister. I may not abide by his directions, his or her directions. Then this will affect the collective responsibility of Delhi government to the Assembly of Delhi. CJI also observed, Honorable CJI, that if a democratically elected government is not given the power to control the officers, the principle of triple chain of accountability cannot be upheld. So civil servants, I explained this earlier, civil servants are accountable to the ministers. Accountability. Ministers are then accountable to the elected representatives. Accountability. And further, third, elected representatives are then accountable to the people of Delhi. This is the triple accountability. So to maintain this chain of triple accountability, we have to ensure that the ministers control the civil servants. Now from this topic, UPSC has already asked 2 questions in the main examination in 2016 and in 2018. So for this year, 2023, this topic again becomes important. If you want a detailed video on the various provisions of Part 8 of Constitution, the provisions regarding Pondicherry, J&K and Delhi, you may type yes in the comment section. Then we will have a separate video, a separate discussion over the Part 8 of our Constitution and the various provisions on the governance of Delhi and other UTs. Thank you.